Good morning and happy Friday. We are joining you here today from Cook Baxter Immigration. I am attorney Hiba Galib and we have partner Danielle Claffey.
Hi.
We are here to answer your questions as usual every Friday and also kind of go over some hot topics and answer some questions again about anything that you might have questions about.
Mm-hmm.
I have my Facebook pulled up, so hopefully, oh, there it is, so we can see your questions as they come, and if we don't address them right away, if we don't address them right away, we will respond at a later time. We're going to talk about a couple things today. We thought it would be interesting because there's a lot going on in the news about immigration. We thought it would be interesting to address some of those misconceptions and talk about what chain migration really is. And I think it's a misnomer, so maybe we can address that. If we have time, we'll also address some questions about TPS because that's definitely one of those hot topics that people have been coming to us with a lot lately. And then if we have time after that, maybe we'll talk a little bit more about the travel ban and another hot topic on the news with respect to the travel ban for certain countries and how we can get around that if possible with certain applicants. So without further delay, we will get into it. I think the first thing we thought would be interesting to discuss, especially with, there was a lot of talk, I think, a couple weeks ago, I want to say, about Melania Trump's parents becoming U.S. citizens, and that kind of brought up the whole question about chain migration. At one point, our President Trump made a very controversial remark regarding DACA and referencing it and mentioning chain migration. Of course, we know that has nothing to do with chain migration, but if presumably DACA, childhood arrivals basically in the U.S. for many years and eventually are, they're going to continue to reside here and have a family, the question becomes what is going to be the outcome if they have U.S. citizen children that could potentially petition for them, and is that even possible? So we want to address some of that. Most of you, if you're watching because you're familiar with immigration or you have personal, contacts with basically if you know somebody that is in need of an immigration service, or you yourself, you most likely are familiar a little bit with generally our immigration system, but a lot of people are still not very, familiar. It's very complicated, and we want to help kind of explain a little bit how it works and what it really is.
So I think I just want to jump in for a second because I think at the outset when I first saw the article and the stories about Melania Trump's parents acquiring citizenship, and they're immediately on social media there was a firestorm as well, how can they do it, and a lot of people really being critical who are not necessarily opposed to immigration but just being critical of the fact that they were able to acquire their citizenship, and presumably they were able to acquire their citizenship because they got their green cards, again, generally assuming, but I think we know it to be the case, through Melania, because of course she's a U.S. citizen, and so how it works is they're immediate relatives of one another. So Melania is over 21 years old, she's a U.S. citizen, and either her parents would have consular process for a green card, or maybe they were in the United States in some other lawful status and she petitioned for them. Either way, it would involve her petitioning for them. And so what I want to stress first is that, in response to a lot of that social media criticism about them being able to acquire citizenship, well, we're supportive of that because it is the law. They were eligible, presumably for all of their reasons, eligible to acquire green cards through their daughter, then to move on to citizenship. It's not that we're being critical of that. What we're being critical of is the whole idea to come down on chain migration, or the belief of what chain migration is and the double standard of that. The whole idea is, of course, we're accepting and supportive of the fact that Melania Trump's parents were able to acquire status, citizenship, and so on as a result of their daughter being a U.S. citizen. So to be critical of that would be, again, we'd be hypocritical in and of ourselves to be able to comment on that negatively. So the whole point is that's just an example of the lawful way that somebody can immigrate to the United States, that it's perfectly acceptable under the law, and it happens all the time. and it's legitimate, it's lawful, and there's no reason not to pursue it if eligible. So I think that's just what we wanted to clarify.
You mentioned the term immediate relative. What does that mean?
Okay, so it can be really confusing sometimes to understand how somebody can acquire a green card through a family member. And a lot of times when people come in for consultations or we meet out at events and things like that, most times people don't understand the difference between what's an immediate relative and what is a family member that falls under what's called a preference category. So the first way to explain that is an immediate relative is somebody who can immediately file for a green card upon also the filing of a family-based petition, okay? But that also has to assume that the person is eligible to file for a green card in the United States. Some people are, some people aren't. Right. So you can still have an immediate relative relationship, which would be a son or daughter over 21 years old who's a U.S. citizen petitioning for a parent, or a spousal relationship, or a U.S. citizen parent petitioning for a child who is under 21 years old. Those are all immediate relative relationships. That in and of itself is not necessarily what confirms the ability for the beneficiary, the person applying, to be able to apply for their green card in the United States. That's a second step question. That person sometimes can apply for a green card in the U.S. Alternatively, a lot of times may have to do what's called consular processing because they're still not eligible to apply for a green card in the U.S. The reason is oftentimes because they may have entered the United States without papers, without a visa, and are not otherwise qualified under an old law that falls under, that gives them an exception to having a consular process. So that's the initial. That's what an immediate relative is. Versus the preference categories. So the preference categories are anybody who's a non-immediate relative. And that's different examples of that are a lawful permanent resident spouse filing for their spouse, or an LPR parent filing for a child, or a U.S. citizen parent filing for either a child or an adult son or daughter. Right. Those are all preference categories. And really what that means is they can't immediately begin the green card process or consular processing for a green card. They have to wait in that infamous line that you hear about. And that line can be anywhere from a few years, 2.5 years I think is the current priority date waiting time for an LPR spouse sponsoring their husband or wife, or upwards of 15, 18, 20, 30 years. When you hear those stories about fourth preference category, right, which is a brother or sister, it's a sibling petition, and then from certain countries like Mexico where it can take many, many years. Yeah. Those are all the preference categories. That's what denotes somebody having to wait in line to be able to apply for their green card.
And what's important to understand is when we're talking about the preference categories, when the person, the beneficiary, is waiting in line because a family member petitioned for them, they're not waiting in the U.S. They cannot adjust or they're not able to benefit from that petition while accruing unlawful presence unless they have any other way to stay here. They're not allowed to wait here.
Right.
And so just to give you an example, I actually printed out the visa bulletin for this month, and this is how you can figure out how long the line is. And it's issued every month. It's updated every month by the Department of State, their website, state.gov, and you can find out, for example, so you can't see this probably from where you are, but the preference categories, F1, F2, F3, F4. F2 is split A and B, but in short, there are 4 categories. The fourth preference, if you're from the Philippines, you're waiting about 18 years. 1995 is the current processing time. That means
23
that people
years.
filed.
We're not math majors.
No, I know, but I was way off with that one. That's why we go to law school. But anyway, we're talking 23 years where someone who is waiting on their relative to be able to join their family member in the U.S. has to wait that long just to be able to benefit from a family preference. And this is what we know as or what they call chain migration, but it's what we know as the system, which is family-based immigration, family unity. I know that it's controversial. I think the reason why people that are against, I guess even our current lawful, legal system when it comes to immigration is because there's this sense of allowing the wrong types of immigrants into the U.S. to make it easier for people that we don't want necessarily to enter the U.S. And it's almost one of those just, I would say, you can't explain it other than it's just a xenophobic kind of a way to address this concern, because there are, this has been our system for basically as long as, I would say, as long as our Immigration Nationality Act has been around, there's always been a family, and sometimes it has obviously evolved over the years, but there's always been an element of family-based, family unity as part of the basis for our immigration system. Of course, there's also a whole separate preference category for employment-based cases as well, and of course that those, there's also different, lines as far as how long those lines are, depending on the background of the person that's applying and the sponsor and the type of job they're being sponsored for, or if they're an extraordinary ability, for example, it might be a shorter line, things like that. But it's just important to understand when we throw out terms like chain migration, if for example someone, let's just say, I think what they're mentioning about DACA, if this person was brought in as a young child, for the most part, they weren't brought in with the visa, that person's never going to really be able to benefit from a petition that even their U.S. citizen child, even though they're immediate relatives in the U.S., they'll never be able to benefit from that petition unless they, with very small exceptions, because of the fact that they aren't eligible for an adjustment of status in the U.S. And that's something very important to understand. This is our current system. We don't necessarily think that this is a perfect system. In fact, we all, I think, agree that there needs to be a lot of updates to our current system, and we've been pushing for comprehensive immigration reform. But I don't think attacking our current system is the answer as well, especially because, it's the only thing that we have at this time. And we need to encourage people to follow the rules that exist.
Yeah. So here's one thing that I want to mention while we're talking about the different preference categories and how somebody can acquire a green card through family-based petitions. And the reason I want to bring this up is because to me, it never gets old, because the question comes up time and time again, because people in the community receive incorrect information, whether it's from notarios or whether it's from other immigration attorneys or people in the community that are improperly advising them. So I can't tell you how many times over the years, and I say it again because it just came up yesterday, where unfortunately a family fell victim to this, where I have parents come in to have a consultation, and they have they have children born here in the United States. They've been here for many years, 15, 20 years, 25 years, and they tell me, well, I want to find out how we can now obtain status because our son is now 21 years old or in his 20s, and we want to come see what we can do because we heard that we can now file for a green card through our child because he's over 21. Right. So we of course go through our standard line of questioning, because we have to vet that really carefully and determine, can this person, this mother and or father, really file for a green card through a parent? Because again, the important thing to remember, even though I talked about immediate relative categories and a child over 21 being able to sponsor a parent, I also said that does not necessarily mean that step number 2, filing for the green card in the U.S., is a viable option. Right. Again, because if somebody enters the United States without papers, and unless they fall and qualify under an old law that's called 245I, where a petition was filed on their behalf before April 30th of 2001, we still have to look to see, can this parent, this mom and or dad, actually file for the green card through their child? And I can't tell you how many times, and again, it just happened, we had a family come to us and say, we don't understand, we don't know what went wrong. So the general typical scenario is, again, mom and dad are here, been here for years, child's over 21, what can I do? And either they're asking us at the outset before they've done anything, or they've already gone to somebody else who's processed a case for them, and then all of a sudden they realize at some point that they can't actually get their green card here. Or the third and worst alternative is that person helping them or advising them, notary or attorney, tells them, well, you can actually leave the United States and get your green card by consular processing, meaning going for your green card interview at the consulate abroad. And don't worry, you'll be eligible because, again, your child's over 21. So the most important thing to know is that if you're not eligible for the green card here and you have a child who's petitioning for you and you're a parent of that child, and you don't qualify for the green card here, there is a very, very good chance that you also will not qualify for the green card once you reach the consulate to go to your immigrant visa interview. And the reason is because, again, if you've entered the United States without papers, you have to otherwise be qualified, right? So the problem is the moment that parent's going through the process for the green card and they get scheduled for their interview, the moment you step foot outside of the United States, okay, you're going to automatically have a 10-year bar. It's called a ground of inadmissibility. It means that you would have to wait 10 years before you can lawfully apply for permission to return to the United States or file for the green card through your child. Now, oftentimes, and we process these cases every day, in spousal situations where we actually can process that because there's something called the I-601A provisional waiver. So that's the forgiveness waiver that's filed in the U.S. That waives that 10-year bar that the person is going to have the moment that they leave. Right. So it essentially clears the path for them to then go to their interview and be able to return lawfully. The problem with the parent-child relationship is, in order to be eligible for that waiver or a regular 601 waiver, which is filed at a consulate abroad after you've already left the United States, in order to be eligible, you have to have a qualifying relative. And a qualifying relative can only be a spouse or a parent who's a lawful permanent resident or a U.S. citizen. Children under or over 21 do not count as qualifying relatives for that waiver. So again, I have seen the worst case scenario where a family member has already left, and then we're hearing from another family member, oh my God, this happened, we don't understand how they're not eligible to come back, and I have to explain this is what's happened. Fortunately, a lot of times we catch it before the person has left, but potentially after they've spent a lot of money, a lot of time, legal fees, filing fees, and so on, to go down this path that was never going to result in anything. And so I'm just bringing it up again because it just never seems to go away. And again, it just came up yesterday where we're trying to, really help a family. And in the long run, we can't help them to acquire status because they don't have that eligibility, through that child. But we're just simply trying to help them out of a financial hole and wasting of a lot of application fees and so on.
So there's no such thing as anchor babies then?
There is no such thing. So again, the only way, and I think sometimes people confuse this because they don't understand, sometimes you can benefit from having had children in the United States. That only, again, though, generally speaking, is if somebody unfortunately is picked up, put into immigration proceedings, has to go before a judge, and then they may qualify for something called cancellation of removal. And that's where you show you've been here for at least 10 years and you have qualifying relatives. In that type of application, which is a version of a green card application, children are qualifying relatives, but that is definitely not to be confused with the more traditional path of applying for a green card, not before an immigration judge.
Right.
So it's two completely separate processes.
This is very important because we get a lot of questions about this. And honestly, if you're not in removal proceedings, then you don't want to be in removal proceedings just to benefit from a potential defense from deportation called cancellation of removal. And so just to summarize, I think it's important to highlight what Danielle said, is that you've got two kind of applications going on when you've got a family member filing for you. You've got a petition that they file that anybody can file as long as they're related, within the family relationships that we just discussed. But that doesn't change your status alone. That would be just the foundation for which a green card process would be based. And whether or not the person is eligible for a green card here or abroad will depend on the inadmissibilities or any, not just unlawful presence in the U.S., but also maybe criminal concerns that could potentially inhibit them from adjusting. For example, even if they're immediate relatives, maybe they cannot adjust because they've committed a crime or they have any other inadmissibilities. For example, some common ones that have come up lately that may not be well known are false claim to citizenship. If somebody's applied for a driver's license claiming to be a U.S. citizen, our immigration laws really are very strict about any false claim to citizenship, and that inadmissibility isn't even waivable. Potential questions about fraud. Unlawful presence is one of the main kind of more common concerns that we see every day, meaning your time in the U.S. either overstaying a visa that you did have at one point or entering the U.S. without inspection and having to figure out how to adjust status from there. Those are definitely they're going to inhibit your ability to get status, but also your unlawful presence, also the other concerns that are in our INA, that in the laws of immigration law that are pretty complex, that we would recommend having if you are concerned about anything at all. former deportation orders. We just talked about it as I was walking in. Some people
Right.
that are adjustable, thinking, they entered with inspection maybe, but didn't know that they got deported. Sometimes people get deported, processed for deportation, and don't even realize
Right.
that they have
Not
an
updating your address.
Yes.
Old applications pending, and then they let it
Yes.
go for one reason or another, changes in your life, family circumstances. They don't update addresses. They end up with a denial. That denial goes to the old address. They're then issued, a notice to appear to go to court, and they find out only years later when they come to us and we're checking backgrounds and things like that. Wait a minute, you had
Potential
court
encounter.
documents and things that were sent to that old address, had no idea.
Right.
So,
So long story short, this is a lot of information and we spoke really fast, so we understand if it's too much. But this is hopefully just to hone in on the fact that it's very complex. It's not as simple as it sounds. It's not, unfortunately, easy, and so it means that you will need help, most likely trying to navigate the system of lawful or legal immigration. And hopefully we're here for you if you need it.
So we did have a good question that came up, and it was actually in one of the topics that we were going to touch on a bit. The question is, my friend has TPS for more than 5 years. Her record is clean, but she wants to know if she can apply for permanent residence. So that's a bit of a broad question, right? So the initial answer is there's not an automatic path from TPS to a green card. There still has to be some other viable path. It's just that TPS, of course, is temporary protected status, and it gives that person, that friend, permission to be here for as long as the person has TPS.
That's all it does. It allows them to stay.
Right,
to
but there's
work
not
and
an
live.
automatic bridge or connection to a green card. So let's just explain really quickly the ways that somebody can acquire a green card if they have TPS status. This is the biggest way. So over the last few years, what we've been doing quite a bit and have been very successful on is anybody who has TPS status is also potentially eligible for what's called advanced parole. Advanced parole is applying for special permission to be able to leave the United States briefly and re-enter the United States. So as we know, oftentimes somebody who's here and has TPS status may not have an underlying lawful admission, meaning they may still have crossed the border many times without papers, but then eventually were able to acquire TPS. Well, then applying for advanced parole, it's an application right now. It is taking a good 6 months to be able to get it approved. But once approved, USCIS will give you authorization to be able to travel internationally, generally to your home country, for a brief period of time. I mean, initially we were seeing it for a week, couple of weeks, 90 days. I actually just received one that was valid for a year for a client. Not that I would recommend that, so that's another question and something to navigate with your attorney or whoever's helping you with it. But in any case, that advanced parole document gives you special permission, so it's a national of Mexico, national of El Salvador, return home to El Salvador for a month, whatever it is. Upon return with that travel document, you present that at the port of entry, you are then being given a lawful admission to the United States. So that lawful admission changes oftentimes that person's ability to be able to file for a green card in the United States where they may not have been eligible before. So where that can come up is, let's say somebody is married to, a U.S. citizen, and for one reason or other, they had not gone through the process of going through the whole waiver and consular processing and immigrant visa interview abroad, but they've traveled on a parole document. They have a lawful admission. They then would be eligible to file for a green card in the U.S. And that can be fairly straightforward. Where I think we're going to touch on for just a minute is the employment-based option. And this is becoming, it's complicated, but it's also possible. And so it's becoming more and more of a viable option and really something to look into, especially in light of the fact that, of course, unfortunately, TPS is phasing out for so many countries, right? And so a lot of people are in a state of panic because they're wondering, what will I be able to do? I've been on TPS, since 2001, and
but they've been here working for companies and potentially for the same
acquiring
company that's
experience
interested to sponsor them. Maybe they've accrued some experience and some skills that they could potentially be sponsored for a visa.
Right.
By that company that is interested in keeping these employees. So the question is, we know that we've addressed the concern about the admission when it comes to an applicant through family-based, if it's an immediate relative petitioner like a spouse, for example. But what happens if your company's sponsoring you and maybe your priority date's current, you can process everything and still be within your TPS validity period, but your admission allows you to enter, but you're not technically. Are you an immediate relative of your employee, employer? How does that work?
Yeah, so this is where it gets complicated and where it's not as straightforward as an immediate relative type of case. Because first of all, what has to happen in order to be able to file for a green card through an employer, there's 3 major steps that that the employer has to go through on behalf of the beneficiary, their prospective employee. First, you have to file what's called a labor certification application or PERM application with the Department of Labor. Well, in order to go through this process where an employer is going to sponsor you, it doesn't necessarily have to be your present employer. It can be any employer who's willing to sponsor you for a position, okay? And this position, oftentimes in this context, can come up as either unskilled labor or skilled labor. And skilled means somebody with at least 2 years of experience in a specialty field. Sometimes we've done it for painters. I mean, all different sorts of where somebody's acquired specialized experience because of the work they've been doing here in the United States. So that's one thing to navigate first, is what specific category under the employment base is the appropriate one. And one thing that's important to note that can complicate it a little bit is oftentimes somebody's been employed by a certain employer for any number of years, and of course they have a good relationship, and so the employer says, well, I'd love to help him or her. How can I do that? What we have to make sure of, though, is that if we're doing skilled labor where it requires at least 2 years of experience in that particular specialty or field, we have to make sure that that experience was acquired before the employment of the sponsor, of the employer who's going to petition for that person. So let's say you can't be employed by company A for 10 years as a painter and then have that same employer petition for you for a green card only using that experience that's acquired through that employment. You have to show that you have independent experience in that same field that was acquired before, that you have other experience through different employment, okay? Because you can't just gain the experience through that employer and then have that employer turn around and petition for you. That's where it gets complicated. That's why it's also really important to make sure that an attorney is going through the process with the employer and the employee. But again, where it also gets complicated is you get through that part, you then file the I-140, which is an immigrant petition. It's the employment-based side of the I-130, which is the family-based. Hopefully we get that approved. Then the third stage, can the person actually apply for a green card in the United States?
Yes.
So the benefit of this advanced parole entry in TPS is that in fact they can in certain parts of the country. So that's where it can get complicated because there's the circuit courts, which are the big federal courts that are right below the Supreme Court, and they're separated out by circuits across the country. Some circuits, including the 11th Circuit, especially the 11th Circuit, which is where we are, okay,
Georgia.
has issued a decision that says that somebody who's on TPS has not made does not have a lawful status in order to be able to then directly file for a green card. Other circuits say otherwise. So if navigating this process of TPS, then an employer sponsoring you for a green card and so on, that's one very important issue to discuss, is where and when and how you can actually go through the process of the final stages for the green card, depending on what part of the country you actually reside in. So again, it's complicated, but it can be possible, and it's something certainly to look into again as TPS is phasing out. Okay.
All right. Well,
All right,
thank
guys.
you guys for your great questions. Again, we'll follow up with you if there are any others.
Yeah, any further questions that come in, we'll answer.
Definitely. Thank you for joining us. Have a great weekend.
Thanks. Bye, guys.
Take care. Do we get other ones?
Just
Pickle or peanut?
yeah, that's funny.
Mi inspiración principal es realmente muy simple, son mis clientes. Las personas que toman el sueño americano, toman lo poco que tienen cuando vienen y lo convierten en algo increíble. Todos los días mis clientes me inspiran. Cook Baxter Immigration es la práctica de la firma de inmigración más grande de Georgia, sirviendo a todos nuestros clientes en todos los estados y en el mundo. Nuestros valores más importantes son simples: integridad, honestidad y valor. Es un honor ser reconocido por el servicio que brindamos a la comunidad a nivel local e internacional. Somos Cook Baxter Immigration, siempre al lado de inmigrante.
Por muchos años mi hija y yo fuimos víctimas de violencia doméstica. Consulté con muchos abogados y todos me dijeron que no tenía un caso. Encontré a Cook Baxter y ellos obtuvieron para mí la visa U. Luego tuve que viajar a mi país por problemas personales. Lo perdí todo. Necesitaba un milagro para volver. Nuevamente Cook Buster tomaron mi caso y consiguieron para mí la residencia permanente. Gracias, Cook Buster Immigration.
En Cook Buster Immigration estamos haciendo la diferencia con más de 50,000 casos resueltos.
Diferencia que nos posiciona en el cuarto lugar de prestigio a nivel mundial en el área de inmigración.
Nos importa decir la verdad a nuestros clientes acerca de su caso. Si hay una solución a su caso, tenemos la capacidad y la experiencia de arreglar a tu caso. Pon tu caso en las manos de los profesionales. Llámanos hoy por una cita.
Cook Buster Immigration, siempre al lado del migrante.